Colleagues in this session, a lawyer and a technical expert with extensive experience in computer forensics will share their perspectives on working with digital evidence. Please welcome Andrei Chichulin, St. Petersburg Federal Research Center of the Russian Academy of Sciences, and Ekaterina Tytyuk, senior lawyer with Nextens. Hi everyone.
Добрый день.
Hello, my name is Andrei Chichulin, and I was already introduced Ekaterina, a beautiful colleague of mine. And let's get started. Right, this is who we are. My name is Andrei, and I'm the leader of International Center of Digital Forensics. And because of this occupation, I must, or I'm happy to, well, it much depends on the day, to communicate with lawyers. I talk to them in courts. I talk to them as a consultant. And today's presentation actually is based on my pain. Sometimes it's very difficult for me to find rapport with the lawyers. At the same time, it's a very important part of our job, and that's why I'm here. Hi, colleagues. My name is Ekaterina Tytyuk. I'm senior lawyer of the IP and information technology practice with Nextens. I'm 30 years old and I have 8 years of experience. So I know my looks are deceiving. I'm not a teenager. I am a graduate of a law school, and because my specialization is IP, I have to talk to techies all the time. And besides, I'm very much interested in AI and legal regulation of AI, and this drives me even closer to the technical community.
И, собственно, почему мы здесь?
And why are we here? Well, first of all, because we, the techies, we must talk to the lawyers all the time these days. Well, there is legal practice in court. I am a court expert. I go to court often.
Дел, в которых сейчас нет,
and there are several problems in this context.
Потому что забыли про IT. На самом деле, это не только компьютерные преступления.
IT is involved not only in computer crime. It's not because someone hacked into your computer, you want to find out what happened, you go to the police, and the police finds the perpetrators. No. Almost any case today, it has an IT dimension. Fraud case, economic case, financial, criminal, drug abuse, anything. Everything is it has a digital component. Drugs are sold in the darknet. Signatures are forged. One of the more recent cases that I attended to was about family violence, home violence. The husband beat up the wife, and that gave the start to the case. Of course, it's not to the technical expert to adjudicate the case, but say MRI images, we, the techies, are called to explain to the court whether we see any tampering signs in this evidence or not. Lawyers often become customers for the techie community, like legal tech. AI is used everywhere, and everyone would love to be able to interpret legal documents and then go to the lawyers and discuss with them the documents that an AI hallucinated. And besides, in the digital space, you also need to have bulletproof evidence, right? But sometimes the techies speak language that the lawyers do not understand. Logs, IP addresses. So what is required is translators. So if you are a student, if you are thinking about acquiring a new profession, I suggest that you become this techie interpreter, the translator from the technical language to the legal language. And it's very important also to be able to communicate.
Для начала надо разобраться, зачем вообще юристам нужны мы технари?
So, what use do lawyers have for techies?
Зачем мы сами себе нужны? Ну, мы, в общем, понимаем.
We more or less understand why techies need techies, but what use do lawyers have for us?
Пожалуйста.
The floor is yours. Oh, okay. Okay, it's my turn. Right. Why would a lawyer recourse to a techie? Now we'll try to avoid legalese. Fortunately, we are not at an exam on criminal law or procedure. Let me explain this to you in the plainest language possible. Now, first, a bit of literacy training. Before us, you also had a session full of lawyers, and as I was getting to this presentation, I realized that a lawyer is a very general, a very generic name, and many people, when they think lawyer, they imagine man in a suit. But in fact, there are many flavors of lawyers, and depending on what kind of lawyer is talking to you, different things may be required of you. I'm a counseling lawyer. I work in legal counseling, consulting, if you will. And if I'm not going to court, so that is to say, if I'm not called to court, most likely I will be providing consulting during, say, an audit. But when you find yourself in a courtroom and you talk to the judge, that's a very special scenario, and the judge is bound by procedural law, and the whole communication happens within this procedural framework. Now, what questions could a lawyer have to a techie? This is based on my personal experience, and of course, this is not the ultimate truth, but that's based on my practice. Well, first of all, a lawyer may request a technical or an engineering opinion as the lawyer is getting ready for a trial. We'll go back to that later in the session. It's a very special procedure. It is also very much regulated because it's a trial. It's a judicial procedure. And there are other ways in which we get in touch with a techie. I'm an IP lawyer, an IT lawyer, and I may be in need of a consultation from an expert. I was into humanities, and I may not be using the proper terminology. I may not be aware of certain details that might be of use to me in my legal practice. I'm writing a contract, I'm drafting a contract. It's a contract for cession of IP rights, and I need to describe the scope of this contract. Otherwise, the contract will be invalid. And sometimes I fail to define the scope. Sometimes it's just not possible, and then I need to call a techie who will help me define the scope of a contract. Or take another scenario, when we work on an audit, sometimes a business owner wants to find out whether he or she is running any IT risks. For instance, it's a software vendor, and the company would request a legal check, really, a review. What are the risks? Is the company looking at any losses? Or say there is a divestment, or part of the business is being sold, or the whole company is being sold. So when the lawyers are called to work on an audit, on such an audit, we cooperate with the techies. We need to find out, I don't know, lots of weird things like what are the working hours, for instance, or which labor contracts are used in the company, how is teamwork structured, how is information input into Jira. So we need these details from the techies, but we are not always met with understanding, because they do not sometimes understand what is exactly that we are requesting from them. Without a clear explanation from the techies, we on our side wouldn't be able to perform our job. And another quite popular avenue of work, and many businesses are already considering that, legal tech products, the development of legal tech products. Obviously, lawyers too would like to be able to use state-of-the-art technologies for their benefit, and special products can and are developed and can be developed. So we as customers go to the techies and describe what it is that we want, and they would produce software that will enable us to draft contracts or find trademarks or whatever. Now, what is the takeaway from this slide? In fact, lawyers will never ask a techie to provide a legal qualification of the case. If you think that someone is asking you to perform the role of a lawyer, that's not true. That's not exactly that. Yes, we may be collecting detailed information, but it will be up to the lawyer to qualify the set of evidence. Now, what is the role of the technical expert during the trial, during the court trial? In very general terms, first of all, the role of the expert is a special role in the proceedings. The expert is not involved in the adversarial process. What I mean is a technical expert, when such a person is called into the process, even if this is done by one of the parties, in fact, the expert is operating from the philosophical point of view on the side of the court itself. So his role or her role is to provide information, to provide facts, and to enable justice. The court doesn't have the skills, doesn't have the competence, wouldn't be able to gather the data and interpret the data on its own. On the other hand, an expert in a trial is impartial and independent. I know that Andrei is going to share some curious cases, funny cases, in relation to that particular slide, but we need the experts to stay impartial, for the court to stay impartial, for the court to take independent resolutions. Experts and technical lawyers cannot, because of that, get together over a cup of coffee and discuss things and change things. This is not how the process is structured. For the expert to retain his or her impartiality, all contacts with the parties to the process, to the trial, must be minimized. Next. An engineering opinion is the source of evidence. An expert's opinion is the source of evidence. Of course, different evidence is used in court. The parties want to be able to substantiate their positions, and the expert provides that information. And different kinds of proof used in court have the same status. The expert's opinion is no better nor worse than any other evidence. However, there is something special that we can say in relation to the presence of a technical expert in court. When the expert answers questions very much, the judge, the court, decides on the case based on the answers received from the expert. So if the code was copied, and that, if the case revolves around an allegation that code was copied, and if the expert says in the opinion that yes, the code was copied, the final decision of the court will also depend on, will depend on that. And we need to make sure that the experts themselves understand how important, how critical their role is in the litigation. The expert's opinion as a procedural document. I don't want to go into details now. If you will have to appear in court, then I'm sure you will be instructed as to how your opinion should look like. There are certain requirements that are set to that opinion, to a procedural document, the expert's opinion set by the law, but there is no template, there is no government standard. And it means that you have some leeway. Hence the problem. Not every time the court will be happy with the expert's opinion. What you need to remember, in case you as an expert provide an opinion, your opinion must be substantiated and reasoned. As we were getting ready for this talk, Andrei was telling me that sometimes experts write lengthy and very serious explanations, but they're just simply very difficult to decipher. Well, first of all, the law asks the expert not only to provide answers to the questions, but to provide a proper explanation. And the court does read the expert's opinion. So the expert is invited to the court, the expert shares the information, provides the information, and there is a good chance that one of the parties will not benefit from the expert's opinion, and then this opinion will be challenged. You shouldn't take it personally. This is an adversarial process. The parties compete. So if one of the parties is not happy, if it wouldn't benefit from your opinion, it will definitely try to undermine your reputation, undermine your conclusions. But you remember that you are not taking the side of any of the parties. You are on the side of the court. You are on the side of justice. I had this professor at the university who taught civil procedure, and he was telling us, the students, that you first need to understand whose side you are playing it in the litigation. So your conclusion should contain a clear answer to the question put to the expert. It's one of the problems, because sometimes experts would write a report that would be so vague that the lawyers would not be able to interpret it in any way, wouldn't be able to derive any useful information out of it, because, you know, this expert examination, it has a certain deadline, it's a resource in the process, and if eventually an opinion emerges, but it's useless regardless of your role, regardless of whether you are on the side of the court or you are on the side of one of the parties acting as an expert, your opinion will lead to nothing. So you have to be absolutely clear answering the questions that are put to you by the court. And we are not always capable of assessing the qualification of the expert per se. We are not competent in the specializations of the techies. Just like mundane people do not distinguish between the flavors of the lawyers, for us it's the other way around. We do not understand the difference in flavors of the techies. We are not always sure that we are contacting the right expert, and we expect this person to actually guide us in the selection process, in the process of selecting an expert.
Well, first and foremost, I hope you're now clear that lawyers are responsible for their thing, while the techie expert is there to deliver justice. Just kidding, everyone is there to seek justice. So anyway, how does a techie wind up in court? Why would you want to get there, why it's useful, interesting, and something that you should do, and why it might be complicated? There are several pathways. The easiest way, and I guess most of you are linked to cybersecurity and information security, so everything starts with an incident. Something happens, a company does an investigation, a research, you find the culprit. Well, it's up to the court to decide who's going to be at fault. It's up to the lawyers. So anyway, techies prepare the data set. Therefore, data acquisition is a piece of a cup of tea for the techies, so that the law enforcement can go to court. And a techie might be invited as one of the witnesses. Actually, Ekaterina might want to correct me because a tech expert is not a witness in a court of law. He is not even a person. He is like an evidence, like a piece of paper that says, well, it could be a knife covered in blood, and a techie is just like that, just an evidence. You are not a party to the trial. So, like I said, one of the possible pathways is an incident. In my case, it was a different story because I was caught in something interesting. I was asked whether I wanted to become a technical expert in a trial. I didn't know what I was getting into. I had two reports, a 400-page long report and a 300-page long report. And then I decided I wanted to focus on digital forensics primarily. But it was a great experience gained. I talked to people who perceive everything in a different way. Because, you know, in a court of law, it's the lawyers who phrase the questions. And they tend to do that in a very weird way oftentimes. The reason for that is quite simple. When a lawyer asks you a question, you can find 70% of the answer in a question. So they phrase the question in such a way as to get the answer they want. And there are two parties to any trial. I love questions that I sometimes get. Let me share the most recent example. An IP rights trial, programmers developed some piece of software, and another company laid a claim to most of their work. So how do you phrase the question? And the question was as follows. Did the programmer display his capabilities in a very original way? The first thing that came to me, to my mind, was a programmer dancing on a table while developing a code. Is that an original way? It is. Well, I do understand what they're driving at because I'm an experienced techie. But like I said, questions might be absolutely weird. And the problem is that a techie has to answer the questions precisely as possible. And even if I understand that the question is phrased in such a way as to mislead you, and for instance, was there an opportunity to hack a system? Of course there was, because being a technical expert, it's always a question of probability. What's the probability of meeting an elephant in a St. Pete street? Well, it's a 50-50 probability. You either meet one or you don't. What's the probability of the evidence being forged? It's never, the probability is never zero. For me, it's always a duality. And the lawyers want a precise answer, a yes or a no. And these phrasings, these expectations result in misunderstanding. A techie might spend days, weeks, or even months to do research and then say, well, highly likely it was not forged, and it will not stand in a court of law. Highly likely is not going to make any of the parties happy. And Ekaterina already mentioned that, but, you know, techies are not a party to the trial, but his opinion is not going to be liked by one party or the other. But if you are vague, then no one is going to be happy. They will just say that this is an incompetent expert. Let's find a good expert, and he will give us a precise answer. And that might be problematic for a very simple reason, because of the lack of mutual understanding. So,
он получает на ограниченный набор данных.
You get a limited set of data, and that's another problem.
Технический эксперт, там приходят данные.
Let's say you're a techie, you get some data. The first problem is that the data is not enough, and the second problem, there could be too much of data.
У меня сейчас идет одно дело.
For instance, I received recently 2 hard drives, and there are more than 4,000 pages devoted to the trial, over 20 or even 30 hours of videos, lots of images, and I don't need all of them. And the case is about a code, a programming code. And what this information lacks? It lacks programming code, because there is no programming code. So using videos, using commercial description of a product, I have to draw a conclusion whether IP rights were stolen or not. So on the one hand, there is a lot of data, but on the other hand, there is no data whatsoever. You can request additional data, but usually it delays the proceedings. And secondly, it's not always that this data is actually available. And parties are interested in their own things. I was once warned that I'm not gonna get access to a computer based in Moscow, but I took a train to Moscow. I took a photo of a closed door. I knocked the door. I was told that I will not be let into the building, and I left back to St. Pete. I loved visiting Moscow because the city is nice. But nevertheless, this is just an example of a case that you might come across. And indeed, almost always, any expert opinion will not be liked by one of the parties, and they'll try to prove that you are an incompetent expert. So what does it result in? There was once a case when I spent much time to talk to the judge, and then he asked me, so ultimately, what happened? Was it stolen or was it not stolen? It's not up to the techie to decide whether it was stolen. So that's why I guess this lawyer addressed this question to me. A wrong question to address to an expert results in the fact that the court is not happy with the response, not just because it does not meet the justice standards. It just does not have any value. It does not create any value. There were cases when 2/3 of the questions addressed to me ended in this very response: not enough data, or I cannot take the question. And if I go beyond my pay grade, for instance, I'm not an expert on legal issues, right? I'm as stupid as this table. I know certain things, but I'm not an expert on the legal issues. But some of the questions phrased by the lawyers, they are way beyond and above my pay grade. A technical opinion might be too techy in the language used, and the judge will not just understand it. Going back to the very first case I was involved in, one of the companies started to actively download data from one of the social media, and they used the web access. Everything was quite clear-cut, and they used it for scoring purposes. And the social media got offended that it was parsed, and it went to court. And my opinion was 400 pages long. I spared no effort, and an entire day was spent on discussing a very simple question. Was the data copied? For me as a techie, zeros and ones were on one computer, then they turned out to be on the other computer, and there is a match. But copying is prohibited by law. Therefore, the wonderful lawyers of the opposing party, the defendant, said, "What's the purpose?" And I say, there is no difference, because zeros and ones were on one computer, now they're on the other computer. And I said, but we deleted the data within the hour. And I say, so what? But this is not copying, that's caching. And caching is not illegal. and I go, hold on a second, zeros, ones. No, hold on a second, the purpose is important. And then I say, agreed. If you delete the data within the hour, I have no questions. But the last names, first names are stored in a database forever. Elasticsearch can be done there, and it's part of the database. Yes, we admit that we store it for a very long time, but it's indexing. We don't store the data to copy it, or not to create a similar object, but rather to speed up the search for our wonderful customers. And indexing is not illegal. Otherwise, you're going to have to arrest the Yandex, Google, and all other high-tech companies. For caching, you have to imprison all the developers of all the browsers, and in the second case, all the search engines. So one word, an entire day spent on discussing just one word. All the other things that I stated in my report was not important for anyone. And you being a techie, face wonderful lawyers, and you have no clue what's going to be important for them and what it is that they're going to use in their arguments. And that's exactly what the judge is going to be interested in. That's why there is a gap between a lawyer and a techie. We understand the questions in our own way, and we give an answer that we believe is a correct one. And it is correct. If you don't lie in a court of law, it's a criminal offense, so I never urged you to do that. But your truth, might be misunderstood. It could be harmful to everyone, not just because you are terrible, but just because you have a different version of truth. You have a different understanding of truth. This is an expectations gap. Lawyers expect one thing, and techies are prepared to give a totally different thing. And now we're going to be talking about the expectations gap. Right. I will be speaking on behalf of the lawyers to describe the so-called expectation gap. Andrei mentioned that time and again, so we're talking about terms and definitions. Let's be clear that lawyers have a definition for everything, and these definitions are precise. For instance, this particular slide gives you a quote of a definition. Any paper, any memorandum, any document starts with a definition. And these definitions might seem weird for the techies, useless, and stuff like that. But for us, definitions are important because definitions serve as a basis for the qualification. From the legal standpoint, who is the subject, and so on and so forth. Everything stems from there. Therefore, definitions are super important for us. They are the foundation. The next bullet is also important. Andrei already mentioned that, but we try to shift the blame here, I guess. So the problem is that we do not always understand whether an expertise is possible. We just ask a techie, is an expertise possible? And the techie says yes. And then from the practical standpoint, it turns out that an expertise is impossible because they need some unique hardware that should be imported from abroad, or they would need 1,000 pages of some specific code. And when we start following up with other questions, they say, well, you asked me whether it was possible in principle. It is, but from the practical standpoint, it's not. And for some reason, they omit to mention that. And the last bullet is something that I have already mentioned. Sometimes we don't know whether an expert is a pundit on the question we come to him or her with. We're talking about this problem in general, right? So we actually expect a technical expert to say that he is not an expert if he is not. Otherwise, we will not be able to use his expert opinion, and it's going to be totally useless in court. And ultimately, that will result in wasted time costs, material costs, and nobody is going to be happy about it, regardless of what party you represent. And well, Andrei is an advanced guy, and he writes about lawyers and investigators and prosecutors. Yeah, but these are the definitions of the criminal procedures. In civil procedures, we do not use these definitions, terms and definitions. So I cannot but highlight the gap in our definitions, even the basic ones.
Да. В общем, от юриста слышу, ну,
Right. Lawyers, criminal procedures, whatever.
Плохое понимание.
Well, there is a misunderstanding.
Чуть отвечу на комментарий.
And let me address your questions. I usually get 5 to 6 questions and no materials whatsoever, no data whatsoever. Sometimes I get a request for an open source code analysis, and I asked, is there going to be any open source code? And they said yes. So they transferred 500 pages in hard copy to me. But they didn't have the soft copy, 500 pages of code, and I could not even split the pages apart. So it happens. You get a request for an expert opinion, but you don't have enough data to give this opinion. Is that possible to carry out an expertise and offer an expert opinion? Theoretically, it is, but then it turns out that you don't have enough data, and that results in delays and various problems during the trial. And the very first one, well, indeed, different terms, professional terms and definitions that we use. AI has generated a person with three arms, so it's a mistake made by an AI, not a human. So, like I said, we're talking about logs, protocols, IP addresses, laptops, PCs, and so on and so forth. Traces of changes in certain documents and stuff like that. But what lawyers want to hear is whether there was a fraud, and we cannot give you an answer to this question. We can just tell you what we found or did not find, and sometimes it's not enough.
Все технари меня поймут, а то отсутствие...
All the takers will understand what I say. The lack of traces does not mean that nothing happened. It just means that we did not find them.
С большой вероятностью документ...
And if you go to a court of law and say it's highly likely that the document has not been forged, and it doesn't mean anything in a court of law. Is there a probability that it has been forged? Well, there is some probability, sure, and that causes problems. Under evaluating the scope and the complexity of the work, this is something that happens on a regular basis. Multiply the time frame by 3, increase it 2 more times, and then maybe you will have enough time. Oftentimes I get a list of questions, I get the materials, and I'm ready to answer, just like during an exam. And sometimes you get 500 pages of text in hard copies, and for the first week you don't even know how to go about working with that, and then you sigh and you start coming up with things. And why that happens is that because we have a different focus. Lawyers want something useful for their case, and takers want to give a correct answer to the question. And the objective of one of the parties who don't like your expert opinion, because, in a court of law, there are trial proceedings, is to accuse a techie of being incompetent, and B, of being affiliated by one of the parties. And Ekaterina already mentioned that talking to one of the parties to the trial might lead to the fact that the techie will be expelled, and his expert opinion will be expelled. And lawyers spare no effort to do that. I even quoted one of the lawyers who took part in this particular case that I was involved in. And the lawyers not only ordered my expert opinion, they actually visited my high school, No, I'm serious. They actually went to my high school school, and there is a museum there, and they found out that I was in the same class as top managers of one of the large companies in Russia. We were in the same high school in different at different times, and we were in the same college, by the way, in St. Peter University of Technology. We studied in different times at different departments, and I was really sad to hear that because they are top managers, they are C-suite guys, and I'm just a techie. I was really sad to see that my career did not take off. But the lawyers were wonderful on both sides. And I decided to remain a court techie because when professional lawyers speak, it's like a song because they phrase what they want to say precisely. Their stances are clear-cut and well-structured. It's not like an earworm or some music. It's logic that pats your brain, and this is great. And of course, when you listen to the talented lawyers, when you listen to them trying to prove that you're incompetent, that's funny. But when the lawyers approached me, when the lawyers of one of the parties approached me and they took my calling card and said that they wanted to get in touch with me, I was happy. For the past few hours, they tried to prove that I was incompetent, but then they went out of the courtroom and said, "Well, nothing personal. This is business, but we want to get you a business card." And anyway, in this particular case, they visit my high school, and I hope that the high school is grateful to me. Right. Anyway, what will help us establish cooperation? No matter how many problems we have, we need to demonstrate a way out, which is important. So, Ekaterina, you have the floor. So, what can we do to establish, to improve cooperation from the viewpoint of a lawyer? We will not be talking about proceedings alone. We'll be talking about cooperation in general. So, we have to agree on the terms and definitions. From the very outset, we need to define various terms, and techies might want to explain some specifics inherent in their industries. And by the way, this is also true for lawyers. Andrei already mentioned a story about the word original. Indeed, original is something, is a term that we use when we're talking about intellectual property. The second bullet is more in the arts domain. Unlike Andrei, I majored in arts and humanities. Therefore, as far as techie terms are concerned, sometimes you have to simplify things for us and, use some simple language to drive the message home. We are experts, but we're only legal experts. And when we start infringing on the domain of technologies, of course, we ask the experts to use some simple language to state some obvious things. The next bullet is not always possible because it says joint analysis of a question. During the court procedures, you don't have this luxury, but you might find a way to hire another techie to phrase the questions in a proper way so that these questions can be stated in a court of law. It's like an interpreter from the techie language into simple, from the legalese to the techie language. And, precise questions phrased by the lawyer. This is a comment, this is a bullet for my counterparts. IT guys have a different perception of the world, so we need to phrase the questions as precisely as possible. So, there is no chance of misunderstanding. There is no chance of getting some useless info. If you want to get some precise information, phrase your questions precisely. Right. The neural network finally depicted someone who looks like me, though he looks more Chinese than Russian. Talking to each other is important. It is. And in a courtroom, a technical expert can talk to both parties. However, the parties it's vice versa. The parties cannot talk to an expert, and I love when I'm asked to phrase the questions for other takers. I'm not trying to advertise my services. It's important because, like I said, a question contains 70% of the answer, and my experience shows that lawyers might order architectural expertise, medical expertise, soil expertise, and usually they invite seasoned experts who have written lots of reports. And medical experts are seasoned experts who are quite well-versed in legalese. As for the techies, my experience shows that since there are no specific requirements to be met by techies, for instance, job experience and a college degree are enough. And when you start analyzing someone else's expert opinion, you really understand that it's good from the techie's viewpoint, but I realize why the court got confused. So talk to each other, it's important. And if you ever wind up as a techie in a court room, you have to be well versed on the context. Going back to the originality, you can interpret different words in different ways. And you have to realize that this question was phrased by a person who thinks differently and in different terms. On the one hand, a question should be specific, like a yes or a no. But on the other hand, it should have a more detailed description. And lawyers will not understand this detailed description. I mean, these are great experts who are well versed and tech savvy, but there is a high probability that they will hire another techie whose job would be to dismantle your expert opinion, and you have to prevent that. You have to give a detailed description so that he has no chance to criticize your job. And technical experts, when they submit their technical views, should seek advice from lawyers. Of course, not from the opposite side, but you can go to some outside lawyer, and while you're lacking experience, you can ask them for a piece of advice. For instance, ask them, what did they think when they phrased the questions that you have to answer? So what I'm saying is that we need interpreters from legalese to techie language and vice versa. Mutual respect is another important thing. Sometimes I see very weird questions from the techie's viewpoint. They might seem stupid, but I realize that it's not because, people are stupid, as it might have seemed on the surface. These are seasoned and great people who are better experts in their domain. They're just not versed in my line of work, and that's why they phrase their questions like that. And patience is, of course, something that you're going to need. Because when you try to understand the question and when you try to analyze the data submitted to you, when I have lots of cases coming from the courtroom. For instance, analyze a computer classroom. I once traveled to Voronezh, a wonderful city, and I was taken there. I was driven around. I was welcomed. I was received well, and the CEO of a subsidiary actually presented me with a bottle of moonshine after we were done. Everything was fine. And I had to investigate computers, PCs that back in 2021 were used for something, and all the PCs in the computer classrooms were replaced in 2022. And no one even thought about how I was going to investigate them. You have a computer classroom, you have a techie, so I loved Voronezh, I loved this trip, but I only investigated just one PC that was, for some reason, left behind. The data was still there, so I just analyzed it. And there are lots of things like that.
Каждое судебное дело, в нем есть что-то, что
There are lots of cases like that, just like in a meme, with your ears behind, and you don't have any clue what to do.
И нужно то самое общение. Потому что не только мастерство владения технологиями, которое у всех...
Mastering technologies is important, and we're all tech savvy. We are becoming more tech savvy, and this is true for both techies and lawyers alike, healthcare professionals. All of us are getting better at using technologies.
There are wonderful people who are lawyers, who are very knowledgeable in law, but only through communication and mutual respect. Can we make sure that the logs that the lawyers cannot read, and that the courts who cannot read the logs will arrive
чтобы сделать работу хорошо, зато она всегда находится, чтобы переделать.
at a justified and a well-grounded solution of the case? And of course, it's best if we establish proper communication from the very beginning, not waste time. Once again, my name is Andrei Chichulin, and this is Ekaterina Tytyuk. Here are wonderful pictures. I don't know, well, definitely one picture is wonderful here. Anyway, thank you.